case. If it's not going to be a lie, go for it.
Judge, respectfully,
No, you lied to me.
okay, if I may, Judge, very.
A courtroom in Michigan, December 2024. Defense attorney Edward Martel stands at the podium and addresses the bench before a preliminary examination can begin. His client is Darren Dwayne Wilson. The charge is serious. The hearing has barely started. Martel has a motion.
And good afternoon, Your Honor. Good afternoon to your fine staff. May it please the most honorable court, Edward Martel, P85051. On behalf of Darren Dwayne Wilson, sir, please stand and give your full and complete name for the record. Darren Dwayne Wilson.
Thank you.
Your Honor, please. He tells the judge that a codefendant in this case already had a preliminary examination. He says the victim at that hearing identified a light-skinned, mixed-race male. He says that description does not match his client, who is dark-complexioned. He is building towards something.
Very briefly.
Go on.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court, been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context, for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race, ethnicity, light-skinned male, certainly not my client who's dark brown.
The something is this: the judge should recuse himself from presiding over this hearing. The judge on the bench is the same judge who signed the search warrants in Wilson's case. Martel's argument is that signing those warrants means the judge has already made a probable cause finding. He cites a Michigan case called People versus Barrell.
Your Honor was presented ex parte with two search warrants in this particular case. Ultimately, these two search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor, pursuant to People v. Barrell, which is 391-124, Judge,
he says the law is clear. A magistrate who has already heard ex parte witnesses should step aside when a defendant requests it. The judge stops him.
Whoa. How the hell do you jump to that conclusion?
What, Judge?
Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant. That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion.
He does not raise his voice at first. He asks a specific question. What ex parte witnesses did I hear from? Martel says the judge signed both search warrants. The judge says signing a warrant is not the same as hearing witnesses. He explains what he actually does when he reviews a search warrant. He reads the affidavit. He determines whether probable cause exists within the four corners of that document. He swears in the affiant. He signs. He does not hear testimony. He says this is as simple as that. Martel continues. He argues that the Barrell case still applies even if no testimony was taken.
Record. Certainly, I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor,
the judge asks him directly whether the case language he is citing specifically covers search warrants.
Signed both of the search warrants in this particular matter. Certainly, but
that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position,
does that case clearly apply to search warrants?
That it's not limited to search warrants.
But that isn't what I asked you, Mr. Martel.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to.
Judge, what I'm
Just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they've made a finding.
Judge, specifically, this relates to an arrest warrant, not a search warrant. However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moot. But
I have read, so that we're clear, because you're playing fast and loose with words. So that it's clear, I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant, because I typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual in, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martel, that says under those circumstances the court shouldn't hear it, then show me the case.
Martel admits it is not limited to search warrants. The judge tells him that the very words of the case describe a magistrate who has heard testimony, which did not happen here. He tells Martel that if he can produce language saying a judge who signs a search warrant cannot then preside at a preliminary examination, he should produce it. Otherwise, Martel is wasting the court's time. Martel shifts. He now acknowledges that the court's position may be correct.
The case. Otherwise, you're wasting my time.
Judge, so acknowledged, I would say that Barrell is applicable, and I would also humbly submit, Judge, as the position of the court, that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion so I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take?
He says if the court has heard no sworn testimony, the request is likely moot. But he wants to preserve the record. The judge takes a recess. He tells Martel to think about whether he is filing a written motion and how long that will take. He takes Wilson back to the holding area. Court stands down. When the judge returns to the bench, his tone has changed.
Court recalls case of the People versus Darren Wilson.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. And please, this most honorable court, Edward Martel, P85051, on behalf of Darren.
He tells Martel he is concerned. He says he went back during the recess and had his staff research the codefendant, hearing that Martel referenced at the very start of his argument, the one where a victim allegedly failed to identify anyone matching Wilson's description, the one Martel used to frame the entire recusal motion. That hearing, the judge says, was not held in his courtroom.
You know, I'm a bit concerned. I just take what people give me. But I'm just going to say this. You lied to me at the very beginning of your argument. I went back, had my staff go back. You said that I held a preliminary examination on the codefendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a codefendant is Christopher Harrison, that case number for reference is 24F22251, our case number. That is not the circuit court case number. I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding recusal started with and I hate...
The case number for the codefendant Christopher Harrison is on record. The judge who presided over that preliminary examination was Judge Barr, not this judge. This judge had no involvement in that hearing at all. Martel began his argument with the fact that was not true.
I hate using the word, but it's true. It started with a lie. Then, Mr. Martel, you continued with your lie regarding the import of the case of People versus Barrell, which you cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph to mislead this court. And
the judge uses a plain word for this. He says Martel lied to him. Martel pushes back. He says he never specifically claimed this court held that examination, he says. He was only providing context. He says he made no false representations.
No, you lied to me.
Okay, if I may, Judge, very briefly, I think the record will reflect it. When I cited or spoke about a preliminary examination, I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not. But
you want me to play it back?
Judge, I certainly, if Your Honor, some.
The judge offers to play the recording back. Martel says that will not be necessary. The judge plays it anyway. Martel's own voice fills the courtroom, describing a codefendant hearing as though this judge presided over it, using that hearing as the foundation of the entire recusal argument.
Other time once, so that's fine.
No, if you're going to sit up here and tell me you didn't lie to me, you want me to play it back?
It certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says.
Whoa. How the hell do you jump to that conclusion?
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentations to the context.
Then the judge moves to the second problem. The Barrell case that Martel cited contains a paragraph he did not read aloud. The judge reads it now.
I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't, we can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may.
If it's not going to be a lie, go for it.
Judge, respectfully.
The relevant language says that where an affidavit presented to a magistrate was in conclusory form and did not state any of the underlying operative facts, and no witnesses were examined, the court can perceive no prejudice to the accused in having that same magistrate preside at a preliminary examination. That language does not support Martel's argument. It defeats it. The portion of the case Martel chose to cite was preceded, in the same paragraph, by language that said the opposite of what his motion required. The judge says he believes this was intentional. He uses the word intentionally. He says Martel intentionally skipped the first part of that paragraph to mislead the court. The prosecutor, Miss Hughes, stands and agrees.
I have quite the record to make regarding the one thing that I absolutely have to say, even though I think this argument is clear and where this situation is headed is clear, but the thing that needs to be abundantly clear. I do have a lot to say about the law, and I do have my own cases to cite, but if Your Honor doesn't need those, I'll set that aside. But the thing that needs to be said is the search warrants that Your Honor reviewed are what led to the pertinent testimony today. They did not include the pertinent testimony that would be heard today. Your Honor signed off on search warrants that include facts that frankly are not being contested. The defense is not contesting that these crimes occur. They are contesting the defendant's identity. The search warrants led to evidence of the defendant's identity.
She cites 2 additional cases.
Choosing not, and maybe I just need to, the law is actually clear that a judge who has reviewed and approved a search warrant, even on facts that they will later hear, that is okay, that procedure is okay. And specifically, I turn to People v. Cameron, which is an unpublished case of the Court of Appeals from 2013, and Cameron is Cameron. And in that case, not only did the judge review and approve the search warrant, but that judge went on to be the trial judge, a bench trial judge. And the Court of Appeals said in that case, so the issue that went up to the Court of Appeals was the defendant was claiming that his trial attorney was ineffective by not trying to recuse that judge. And the Court of Appeals said, failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel. That is what the Court of Appeals said about trying to recuse a judge who has previously reviewed a search warrant. The other case that is specifically on point is a
People versus Cameron, a 2013 Court of Appeals decision, held that failing to raise a meritless recusal argument does not constitute ineffective assistance of counsel. People versus Pitchford from 1971 addressed a nearly identical procedure and affirmed that a judge who approved a search warrant could lawfully preside over the preliminary examination that followed. The law was not ambiguous. It was not unsettled. The cases were findable. The judge now raises a second concern. He says the recusal motion, built on a false foundation, combined with an argument that misrepresented the governing case law, looks like something other than a good faith legal challenge. He says it looks like forum shopping. He explains that he was assigned to this case after another judge stepped away, and that this assignment may not have pleased the defense. He says that context, combined with what happened in this hearing, leads him to question whether the motion was filed to delay the proceedings or to land a different judge.
Because I'm going to tell you that, quite frankly, Mr. Martel, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recuse for the purpose of forum shopping.
Absolutely.
Because, I think so. Because originally I had to step into this case, and I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think.
Martel says he had no intent to mislead. He says he stands firm on his word.
To try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to mislead this court or back on the full exam or the transcript thereafter. As far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth if it's the position of the court that it's not certainly, Your Honor, we will move forward with your denial and we're prepared for.
I have not ruled. You will hear my ruling loud and clear.
Yes,
but do not presume that I'm going to deny it.
The judge does not accept this. He does not yell. He says what he observed clearly and then tells Martel what comes next. He orders the recusal motion to be filed in writing.
How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26th, 2024 at 12 noon.
Thank you, Judge.
The deadline is December 10th. The prosecution responds by December 20th. The hearing is scheduled for January 2nd at noon, along with the rescheduled preliminary examination. The judge notes for the record that the defendant, by raising this motion, has waived any time requirements associated with the preliminary exam. Before court adjourns, the prosecutor mentions she is unavailable December 26th, the original date the judge proposed.
Just for scheduling.
Yes, go ahead. No, that's fine.
I am not available on December 26th. I am the person that will be filing the response. I would love to be the person to litigate it as well.
Understood. Then preliminary examination, since this is not of the people's doing, and the defendant, by raising it as well as before, has waived any time requirements. The preliminary examination as well as hearing on the motion will be January 2nd
Thank you, Your Honor.
at 12 noon. 12 noon.
The judge accommodates her without issue. He moves the date. He is orderly. He is precise. What sits underneath all of this is a structural fact worth holding for a moment. Martel was attempting to use the rule against bias to create bias. The argument was that this judge could not be neutral because he had already weighed evidence. The evidence the judge had weighed was a search warrant affidavit. The standard for that review, as the judge himself explained, involves reading a document and determining whether its contents establish probable cause. It is a limited, one-sided paper review. It happens in every criminal case where a warrant is sought. If signing a search warrant disqualified a judge from presiding at a preliminary examination, the rule would swallow the system. Nearly every preliminary exam would require a new judge. That is not what the law says. The Barrell case said the opposite in the same paragraph Martel chose not to read. A defense attorney is supposed to be an advocate. Advocacy has limits. Those limits include the candor a lawyer owes to the tribunal. That obligation exists not because courts need protection, but because the adversarial system only produces reliable outcomes when both sides argue honestly from the facts and the law. When an attorney walks in with a false predicate and a selectively quoted case, they are not testing the system. They are corrupting the process that makes their client's rights meaningful in the first place. The judge caught it during a recess. His staff found the case number. The transcript was available for playback. The full paragraph of Barrell was one more minute of reading. Accountability in a courtroom depends entirely on someone being willing to check.